open the hearing on House Bill 2183, including any photograph, film, video, picture, digital, or computer-generated image or picture that has been created, altered, or modified by artificial intelligence or any digital means in the definition of a visual depiction for certain criminal offenses. And with that, a bill brief from the riser.
Thank you, Madam Chair. House Bill 2183 amends a few different criminal statutes. This is another one where the amendments in the House were pretty extensive, so I'm just going to explain what the bill does now, and if you have specific questions about the amendments, I can take them. Section 1 amends KSA 215510. That's the crime of sexual exploitation of a child. The change in subsection A2 there expands the conduct prohibited by the section to include possessing any artificially generated visual depiction with intent to arouse or satisfy the sexual desires or appeal to the prurient interests of the offender or any other person. In subsection D5 there, you'll see a definition of artificially generated visual depiction, which would mean a visual depiction that is obscene and produced through the use of computer software, digital manipulation, or other means that creates an image or video that appears to depict a child under 18 years of age, shown or heard engaging in sexually explicit conduct. It includes depictions that are obscene and indistinguishable from real children, morphed from a real child's image, or generated without any actual child involvement. The bill also adds a definition of obscene, which is added to mean a visual depiction or artificially generated visual depiction that, taken as a whole, appeals to the prurient interest of an average person applying contemporary community standards, that is patently offensive, and that, taken as a whole, lacks serious literary, artistic, political, or scientific value. Section 2 amends KSA 215611. This is the crime of unlawful transmission of a visual depiction of a child. Subsection A, the term identifiable is added. Oh, it's added in subsection A and B, actually, to describe that child as the subject of the depiction. And in subsection G, which defines the terms for both this crime and for the crime in 215610, which is unlawful possession of a visual depiction of a child, it's amended to include a depiction created in whole or in part, altered or modified by artificial intelligence or any digital means to appear to depict or purport to depict an identifiable child, regardless of whether that child was involved in the creation of the original image. And then finally, Section 3 amends KSA 216101. This is the crime of breach of privacy. The change there in subsection A8 expands the conduct prohibited by the section to include disseminating any videotape, photograph, film, or image that has been created in whole or in part, altered or modified by artificial intelligence, or any digital means to appear to depict or purport to depict such identifiable person, regardless of whether they were involved in making the original image. There's also an amendment to subsection D to provide that the section shall not apply to cable services. And I can take any questions.
Thank you. Committee questions? Not seeing any. Thank you for the bill brief. We do have 4 bill hearings today, so we're going to limit all conferee testimony today to 4 minutes. That seems to be a time that works pretty well. And for our conferees, when there's 1 minute remaining, I will hold up a manila folder. So if you'll check in and see if it's 1 minute remaining, that would be very helpful. With that, then, we will invite our first proponent conferee, Brad Barrett, State Representative, District 76. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and committee members. My name is Brad Barrett. I'm a state representative for District 76. When I'm not a state representative, I'm a criminal investigator for the Shawnee County DA's office here in Topeka, Kansas. In that position, I investigate human trafficking and child exploitation crimes. So where this case came from was I had a local agency in my district, the 76th district, reach out and they said, hey, I have an individual, and they used, this is a registered sex offender who used AI to manipulate a photo of a child. And it's very sexually explicit in nature. And we think it maybe fits statute, but we're not sure. And so with that conversation, I spoke with an FBI TFO. Now, TFO means task force officer. This FBI TFO, all he works is child exploitation crimes on the federal and on the local level. So we started talking about these types of AI cases with this being a new growing technology. And he stated, this just is the cusp of it. He said, AI is getting so realistic now that you can't tell the difference if it's a real child or not. So this material can be, one, it has to be sexually explicit, but you can look at it and think, that's a real child. And you have no way of telling the difference unless you've identified that child. So we found this as a gap in statute, so that's why we updated this first section with it being indistinguishable from a child. So what are we talking about? Well, the first statute this changes is sexual exploitation of a child. So if a child, what is clearly identified as a child is involved in sexually explicit conduct. If you look at the definition of sexually explicit, that's usually some kind of sexual act. It's clearly identified as a child and they're in the nude, then this would fit that statute. In addition to that, we added the obscenity standard. Now, the reason why we added the obscenity standard as an amendment is there were a few members in the House Judiciary who felt that there's an older Supreme Court case law from 2001, 2002, where they're talking about computer-manipulated CSAM. CSAM means child sexual abuse material. And they stated that if it was made by a computer, it was unconstitutional. Now, there was a concurring opinion from a justice in that same law that said that this is subject to change as technology advances. Obviously, AI has increasingly been something that's just been, it's extraordinary how much it's developed. But because of those concerns, what we added was the obscenity standard. So if you look at Supreme Court case law, Miller v. California, that clearly establishes that obscene material is not constitutionally protected. So in addition to that, some may ask, okay, well, let's say this material is completely AI generated. It doesn't affect a real child, right? Well, to that, I would say there's data that says that's incorrect. First, I want to reference the Butner study. This study was funded by the federal government, and they looked at all of these registered sex offenders who were charged with possession of child sexual abuse material. In this study, they found that I'm not going to say all, a vast majority, I believe it was north of 80%, admitted that they had also gone hands-on with a child. They just hadn't been caught with that. These were only convicted with possession of child sexual abuse material. So when they're in possession of this material, there's a good chance they've already gone hands-on with a child. And, sorry.
1 minute.
Yep, thank you. And then the second part I want to add is that by adding the obscenity standard, it stays within the Constitution. Now, the other two subsections are very simple. We're just updating it for AI. So if you have an identifiable child, for example, someone under 18 shares a photo of a child, they use AI to make it nude, that's just including AI manipulation because it looks so realistic you can't tell the difference. The third part it updates is breach of privacy. This is like the revenge porn statute. So this is for adults. So if someone takes a regular photo of you and it's naked, you had the expectation of privacy and they share it, that's illegal. This is just saying if they use AI and make it naked and try to use it against you, that's also illegal. So with that, I will stand for questions.
Great, thank you. We usually reserve questions until after all of the proponent testimony, but I understand you need to get on the floor at 11 in the House of Representatives. So committee, do we have any questions for the representative? I want to thank you for bringing this issue to the attention of the legislature and for your testimony about it today, too. Really appreciate that.
Thank you, Madam Chair.
Thank you. Looks like we don't have any questions for you. Thank you. Next, we will hear from Mike Kege, District Attorney for Shawnee County. Not seeing him, so we'll circle back, but we will next hear from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Ed Klump, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers Association. Thank you for hearing this bill today. We think this is a very important bill. We support it, and Representative Barrett and the reviser did an excellent job of going over what it does. I want to talk a little bit more about the practical applicability of this. It seems like everything created for good things, AI is not an exception. Somebody will figure out a way to use it for bad things, and that's why we're here. And so what happens in this technology, it's advanced to the place where you can take a photo of a person, put it in your computer, use the AI generator, and make that person look like they're doing anything you want them to do. And that includes sexual activity, nudity, things like that the person wasn't engaged in, but it makes it look every bit like they were. And that's why we're here. This is especially troubling when it happens to children. Children have been faced with these issues with inappropriate photos for a long time. Now we have the new thing where they can have a photo that looks like them doing something they never did, but everybody wants to believe they did. And these have resulted in suicides of young people when they're confronted with this because they can't deal with it. People use it to entice people or to kind of force them into doing things they normally wouldn't do for fear of that picture being revealed to family and things like that. Now it's also hitting the adults. Sometimes they'll take a picture, and I'll talk about a case here, but sometimes they'll take a picture, an old picture of a person when they were a child, and manipulate it to embarrass the person as an adult. Sometimes they take the adult picture and try to make it into an image that will cause them embarrassment. And so that's what this is all about. In my testimony, I included a quote from an FBI release from April 29th, 2024 that talks about this. And I just want to point you to that last paragraph in that quote where the FBI agents talk about how extremely realistic these images look. And if you're not trained in how to spot an AI-generated image, they are very, very difficult to determine what's real and what's not. So it's critical we have laws to protect these victims, and that's what we're asking for here today, is to modify our laws. It really doesn't create a new law, it just gets the law to where it covers these AI-generated images, and that's what we're after. And we'd ask for your support on the bill and to move it forward favorably. Thank you, Madam Chair.
Thank you. And we do have now Mike Kage, District Attorney for Shawnee County here. So please introduce yourself and welcome to committee.
Good morning. My name is Mike Kage. I'm the DA here in Shawnee County. I apologize for my tardiness this morning. I understand we're limited to 4 minutes, so I will be brief. This is a common sense bill. It's designed to modernize our definition of CSAM, which has already been explained to this committee. It's been adopted in several other states because they have that same recognition. The AI has propelled us into a new world. And the case, which is cited by the opposition, was settled in 2002. And I'm sure many of you remember, as I do, the capabilities of computer-generated images in 2002 and how they compare to what we see today. What we see today is virtually indistinguishable from reality. There's really no way to tell when you're watching these videos and you're looking at these photos, is this real or not? And that's why we're here. We're here to update the law, to catch up to the technology, and to protect kids. Representative Barrett talked to you about the study which found that, I believe the number is 85% of the participants self-reported that they had prior contact offenses with kids. That means that 85% of the people who had been convicted of possessing child sexual abuse materials actually had also committed sexual offenses against children themselves. So the state has a legitimate interest in safeguarding children, certainly, and we have a responsibility to modernize our definition and do everything we can to keep them from harm. This is not a free speech issue. Free speech does not go unchallenged and unfettered. Certainly there are reasonable limitations that we place on it. For example, I'm not able to make an actual threat of violence against another human being. I'm not free to do that. I'm not able to call others and incite them to violence. I'm not able to possess child sexual abuse materials. And I think the language in this statute, I'm confident, is sufficiently narrow to address any of those concerns and would specifically exempt things like an artistic expression. I'm happy to answer questions at the appropriate time. Thank you.
Thank you, appreciate that. Are there any other persons wishing to testify as proponents on the bill? Not seeing any, then we will open it up for any questions. I have one question before we get started. It's for the reviser. Does the bill apply to AI-generated material of adults as well, if it's depicting adults?
Thank you, Madam Chair. The changes in Section 3 are to the change in the breach of privacy statute, which applies to adults. So if you look on page 6, starting in line 6, this is the form of breach of privacy that we're talking about. It would be disseminating any type of videotape, film, image of an identifiable person 18 years of age or older who's nude or engaged in sexual activity. And then you'll see the change there that we're starting in line 11. So this includes these AI-generated depictions. So that Section 3 would apply to AI-generated depictions of adults.
Thank you. Yes, Senator Argabright.
Thank you, Madam Chair. I think Representative Barrett's still here. Yeah. First of all, thank you for your help on this bill. Very supportive of what's in front of us, and it overwhelmingly passed in the House. There was some opposition. Is there anything with the opposition discussions that we can strengthen this even more that we need to consider?
Well, thank you for the question, Madam Chair and Senator.
Could you go ahead and identify yourself again, just for our record? Thank you.
State Representative Brad Barrett, 76th District. So the original dissent in committee was about that old 2001 case law where there was still some mix. So, Utah went ahead and they passed it. And what we did was to be more conservative and to alleviate those concerns, we added that obscenity standard, because by adding that obscenity standard, U.S. Supreme Court case law clearly states that it's not constitutionally protected. And that's why we also, under the obscenity standard, you'll see that what the definition of obscenity is, we replicate that and we put that in the statute as well, to match the case law and to keep in constitutionally.
Thank you. Senator Rose.
Thank you, Madam Chair. Does the bill speak to if a minor creates the AI image or disseminates the AI image against a fellow minor?
So the second subsection is more for someone under the age of 19 sends it as if like it's a picture of their former boyfriend or girlfriend, and they use AI to make the person appear to be nude. That second section is separate from child exploitation. So for child exploitation, the image has to be sexually explicit in nature. So there has to be usually some kind of sex act, right? And then it has to be obscene in nature. So the second part would apply if it wasn't obscene. Like specifically the second section says it's not obscene. It eliminates that. So it's more for revenge, sharing it. I'd have to read the statute closely to see if they were under 18, if that would still apply. But just to be clear, the first section only applies to sexually explicit conduct that's obscene in nature.
So it just seems to me like for minors, you think about middle school kids, high school kids, that we need to communicate this to them, or else our court's going to be full of teenage boys who are pulling a prank that was against the law.
Yeah, and I agree that in that second statute, you'll see that it's a lower crime, because we don't want them to be on a registered sex offender list. We don't want them, but we still want there to be consequences. But yeah, that first section is just for the obscene material.
Thank you. I have a follow-up question. So does the bill address using AI-generated images of someone, whether they're an adult or a child, engaged in other activities like acts of violence, and you've created a AI-generated picture looking like you're creating a battery on someone? Would that be a crime under this bill?
Thank you, Madam Chair. Great question. So that first section for when it comes to children, it has to be sexually explicit. Where it would apply to adults would be breach of privacy, which is that third section. That's not talking about violence. That's where they have an expectation of privacy and they're depicted in the nude. So it doesn't state anything about violence.
So I guess a question for the reviser, does it only regard obscene or sexually explicit material, and it wouldn't cover generating an AI image of engaged in, violence against another person.
Madam Chair, that's correct. All three sections that are being amended in this bill are related to depictions of people, whether they're adults or children, in either a state of undress, nudity, or engaging in sexually explicit conduct.
Have you thought about the bill then applying to AI-generated material that would be something like, an act of violence being depicted?
At that point, we would just need to speak with people who are very in-depth on like constitutional issues, just because, like I said, adding the obscenity standard in that first part kind of allowed us to create that law. When it's an identifiable person, I honestly, without talking to someone that's, really ingrained in constitutional law, I just couldn't feel comfortable with having that added.
Or maybe it's not even an act of violence. Maybe it's just an other illegal activity, distributing, illicit drugs or something. And maybe that's a question for Mr. Kege. It's not what the bill does currently, but it just, it would be troublesome for AI-generated material depicting an identifiable person engaged in criminal activity in the video. But yes, if you'll go ahead and identify yourself.
Mike Kege, Shawnee County DA, and thank you for the question. I do think that's something that we need to look at some point. As I heard your question, I considered criminal defamation, things like making a false report to law enforcement. There could be applicable statutes already in play depending on how that material is used. But certainly I think, we're just now starting to talk about AI and its impact on our communities and public safety and how we do things as a community. And I think we'll be talking about it for a while.
I do too, and I understand the slander and the defamation, which are civil causes of action. They're not a crime.
There is a criminal defamation statute as well.
And do you know if that's a felony or a misdemeanor?
I believe it's a misdemeanor, but frankly, it's not used very frequently.
Right, and maybe it will be coming more into play if we've got AI-generated images of people engaged in what looks like criminal activity.
Could be time for an update.
It could, yes. An update to the update that hasn't even advanced all the way. Well, thank you for the conversation. Appreciate it. Other questions? Not seeing any, then thank you for your testimony and appearing here in person. Appreciate it. Do we have anyone wishing to testify as neutral on the bill? Not seeing any, then we will invite opponent to conferee Emily Brandt, BIDS Legislative Committee, Kansas State Board of Indigence Defense Services, to the podium. Please introduce yourself and welcome to committee.
Mr. Kege is much taller than I am. Okay. Like Chairperson Warren said, my name is Emily Brandt. I'm an attorney with the BIDS Legislative Committee, here to testify in opposition to House Bill 123. I will start by acknowledging the work the House Judiciary Committee did on this bill to amend it to get to you all today. You have, I believe, my written testimony for this committee and in the House Judiciary Committee. We raised the constitutionality concerns. And I do also want to acknowledge this obviously is a free speech issue. That's why the bill got amended. But we still have grave concerns about this bill. I'll start with in Section 1. We think that House Bill 2183 still fails to criminalize obscenity. And so there are only two material elements to this crime that they've created: possessing any artificially generated visual depiction with the intent to arouse or satisfy the sexual desires or appeal to the prurient interests of the offender or another. So to convict someone of this crime that they've created, you don't actually have to make any obscenity finding. They have buried obscenity within the definition section, within a definition under this law. So I believe, and I think I've got a typo in here, but D5 defines obscenity, D6 defines artificially generated visual depiction. So what you are going to ask juries to do is to find these two material elements and apply these two definitions to those material elements to try and determine if somebody has committed a crime. And quite frankly, a jury doesn't have to find that the material is obscene. because all the definition under artificially generated visual depiction includes is that it includes obscenity. It does not require an obscenity finding. And again, we were the ones who suggested that they add the obscenity definitions from California v. Miller. And so I think to strengthen this bill, to make it meet constitutional muster, this committee should consider actually adding the definition of obscenity within the material elements of this crime. Otherwise, I think that we still run into the First Amendment problems that we raised in House Judiciary. And I know that they keep saying that the law is old because it's from 2000 or 2002, but United States Supreme Court precedent is United States Supreme Court precedent until it's not. It's binding law on the state of Kansas and state courts. So we would respectfully ask this committee to continue to amend House Bill 2183 if it's going to work it. We would also say that House Bill 2183 has unintended consequences for young offenders. I appreciate Senator Rose's questions. 215610 and 215611, those two statutes work in tandem. They are Romeo and Juliet laws. They are intentionally trying not to criminalize youthful offenders under sexual exploitation of a child. That's why this body created those laws, because youths were being charged with the felony of sexual exploitation of a child. First, this bill doesn't amend 215610, which doesn't make a whole lot of sense if we're going to amend 215611 because they work in tandem. And secondly, because you now have this unidentifiable child, law enforcement can now charge youths where they don't know if it's an identifiable child under this new obscenity standard under sexual exploitation of a child. So I think that this body should consider the purposes of initiating those Romeo and Juliet laws to protect youth in the state of Kansas. We also think this solves a non-existent problem. When Mr. Mike Kage testified in the House Judiciary Committee, and as he testified here, this law doesn't create a new crime. It doesn't create a new law. It's not doing anything different, because respectfully, the conduct that they're trying to proscribe is already proscribed by statute. We already define visual depiction to include digital or computer-generated images. The state of Kansas and their appellate court decisions have already said that simulated, morphed, or modified images of actual children are not protected speech. So we would respectfully ask this body not to work 2183, but that if you are going to work 2183, to consider amendments to 215610 and to actually include obscenity in Section 1 for sexual exploitation of a child. And with that, I will stand for questions.
Thank you, and good timing. Appreciate it. Committee, any questions? Not seeing any questions. I do want to ask something, but I want to make sure we don't have any other persons wishing to testify as opponents on the bill. Not seeing any. Then you mentioned 215610, and we're looking here, the bill, Section 1 amends 215510. So you do mean 5610, not 5510.
So 5510 is actually sexual exploitation of a child. 5610 is unlawful possession of a visual depiction of a child, and it works in tandem with 5611, which is unlawful transmission of a visual depiction of a child. These are both considered like Romeo and Juliet laws, so they're meant to protect, like 18, 19-year-olds who are sharing images of their peers, their boyfriends, girlfriends, etc. And so this bill doesn't change a child to an identifiable child in 5610, only in 5611, which again doesn't make a lot of sense because these work in tandem. You'll see that the definition section of 5611 applies to 5610. And again, the purpose of creating those bills was to protect youth. And I think adding this an identifiable child potentially creates a situation where law enforcement go back to charging youths as under sexual exploitation of a child, which is the felony that carries lifetime registration, lifetime post-release, those kinds of things that this body and law enforcement supported. I cited to some of their proponent testimony when this was first up in 2016. The entire purpose is to not criminalize those youthful offenders the same way that we criminalize adults possessing explicit child material.
You don't have any opposition to the page 6 amendment to the bill as it was introduced, which amends 216101. Is that correct?
That's not correct. I just realized that my 4 minutes was running. It's in the last paragraph of my written testimony here. We're just not sure why 61, I'm sorry, are we talking about 6101?
Yes.
Yeah. I wanted to make sure I just didn't mishear you. We're just not sure why we're amending 6101 in the same way that we're amending sexual exploitation of a child and unlawful transmission of a visual depiction of a child. I can understand maybe wanting to update the definition of visual depiction sort of wherever it appears in these statutes. But to us, it doesn't seem, I don't know, it sort of seems like apples to oranges, because in one, we are talking about children in either obscenity materials or in child pornography, both of which are not protected in the First Amendment. And also in breach of privacy, the victim in those cases, they must have some reasonable expectation of privacy. So there's this like additional right that has to trigger in order for someone to be convicted under that statute. And so you have a contemporaneous need for a right to privacy in order to trigger the criminal conduct. And that makes it different from both sexual exploitation and unlawful transmission, because the victim in the breach of privacy necessarily must be involved in the creation of the original image, because they had to have had a reasonable expectation of privacy when you took that photo of them. And there's no such contemporaneous requirement in the other two statutes. And again, the definition section, I think, says that they don't have to be involved in the creation of the original image. Regardless of whether such identifiable person was involved in the creation of the original image. So we don't know why 216101 would be amended like the other two statutes.
Thank you. Any other questions? Not seeing any, and thank you for your testimony. Appreciate it. With that, then, we will close the hearing on House Bill 2183. We're going to open the hearing on House Bill 2242, authorizing the governor to accept requests of concurrent jurisdiction from the federal government in certain circumstances. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2242 amends KSA 27102. This is the statute that provides for federal jurisdiction over land that is acquired by the United States pursuant to KSA 27101. Current law there provides exclusive jurisdiction over such lands is ceded to the United States with certain exceptions for serving process and taxation. This bill would add a new subsection B to provide that the state authorizes the governor to grant requests from the United States to establish concurrent jurisdiction over land that's owned by the United States for military purposes within the boundaries of Kansas. That concurrent jurisdiction would be effective upon a written offer of concurrent jurisdiction being sent to the governor by an authorized representative of someone who has control over that land, the governor accepting that offer and clearly confirming that each of the elements of the offer are accepted, the governor then recording and indexing the offer, acceptance, and the meets and bounds description of the boundary of the concurrent jurisdiction with the Secretary of State, who would publish it in the Kansas Register. After concurrent jurisdiction is effective, the governor would be required to send the information provided to the Secretary of State to the official who made that initial written offer from the United States federal government, and also to any state or local agency, and they would be able to enter into a reciprocal agreement or memorandum of understanding with any agency of the United States for coordination of that concurrent jurisdiction. And I can take any questions.
Thank you. Any questions? Not seeing any. Thank you. We will hear from proponent conferees. I understand our first two conferees are at an off-site location, McConnell Air Force Base, on WebEx. And we'll first hear from, with still our 4-minute limitation, please, Lieutenant Colonel Michael Ramming, Staff Judge Advocate, 22nd Air Refueling Wing, McConnell Air Force Base. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and honorable members. My name is Lieutenant Colonel Mike Raming, and I am the Staff Judge Advocate for the 22nd Air Refueling Wing. It's the host unit for McConnell Air Force Base. We have a couple of other units here on the installation. And joining me today is Mr. Jonathan Sullivan, who serves as our Chief of Civil Law here in the McConnell Legal Office. On behalf of the installation commander, we greatly appreciate this opportunity to provide some information regarding HB 2242 and the potential to allow the retrocession of exclusive federal jurisdiction to a concurrent state and federal jurisdiction model. I did want to inform the committee that McConnell is in fact seeking to modify our current exclusive federal jurisdictional scheme to a concurrent arrangement. So far, we have obtained concurrence of the Sedgwick County Sheriff's Office, the Sedgwick County District Attorney's Office, the Wichita City Attorney, and the United States Attorney's Office. The primary concern that we have is situations surrounding juvenile offenders. We have enjoyed a positive and productive relationship with the U.S. Attorney's Office when it comes to addressing allegations of civilian misconduct here on McConnell Air Force Base. But should there be an allegation of a serious juvenile offense, we simply don't have the same tools at our disposal for both juvenile justice and juvenile rehabilitation that our community partners in the state system have at their disposal. And with me here is Mr. Sullivan as well, who works in my office.
Sure, we'll hear from Jonathan Sullivan, Chief of Civil Law. Please introduce yourself.
Yes, Madam Chairman, I'm Jonathan Sullivan. I am the Chief of Civil Law here at the McConnell Air Force Base Legal Office. In addition to my duties in that role, I also serve as a Special Assistant United States Attorney, which allows me to prosecute civilian misdemeanor offenses in magistrate court on behalf of the United States Attorney's Office in federal magistrate court. And it also makes me the de facto liaison to them as well. And prior to taking my position here at McConnell Air Force Base, I served as a juvenile prosecutor for Sedgwick County for 22 years. And bottom line is that the federal criminal justice system does not have the same options to address juvenile criminal behavior that the Kansas state system has. And in an extreme case in the federal courts, the U.S. Attorney's Office could seek to prosecute a juvenile as an adult, but in anything short of that, we'd have very few options available. And thankfully, we have not faced that situation at McConnell, but it does happen within the Department of the Air Force. And if the legislature does pass this bill, it will open the ability for McConnell to work with our local community partners to ensure that our military community is as safe as possible and that any alleged juvenile offenders are afforded a fair process in a system that is properly designed to protect their rights, protect the rights of victims, and properly balance punishment with juvenile rehabilitation in the event of a conviction. And with that, Lieutenant Colonel Raming and I are happy to address any questions you may have.
Thank you, gentlemen. If you could stand by for questions when we're concluded with hearing from the proponents. We'll next hear from Michelle Reichert, Midwest Regional Liaison, United States Department of Defense State Liaison Office. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and honorable members of the Senate Committee on the Judiciary. My name is Michelle Reichert, and I'm with the Department of Defense. Specifically, I'm the Midwest Region Liaison at the Defense State Liaison Office. The Department of Defense is grateful for the opportunity to support the policies reflected in House Bill 2242, which addresses concurrent jurisdiction on military installations. I have submitted written testimony, but also want to give you a little bit of background of where the impetus of this policy came from. In 2018, the Wyoming Law Review published an article by now Lieutenant Colonel Rob Levine, an Army officer, on the need to establish concurrent jurisdiction on military installations to protect children. This article references a truly egregious case which had occurred on Fort Lewis, where a 7-year-old boy was raped by a 13-year-old in a wooded ravine near his home on base. Because the state of Washington had ceded or given exclusive legislative jurisdiction to the federal government over land that would become Fort Lewis way back in 1917, the state could not subject the juvenile offender to its laws. And the federal system, as you heard, lacks an effective mechanism for handling juvenile offenses. Without concurrent jurisdiction, there is a black hole for juvenile justice on federal installations. Federal prosecutors routinely decline to prosecute juvenile and juvenile sexual assault cases, and local prosecutors lack legal authority to apply state laws to juvenile criminal conduct on federal lands. To be clear, these cases are rare, but no less important. In the 1970s, Congress passed legislation allowing the federal government to relinquish all or part of federal jurisdiction of the United States over its lands back to the states. This process is giving back jurisdiction. This process of giving back jurisdiction is referred to as retrocession of jurisdiction. And this was done by Congress in part because these areas with exclusive federal jurisdiction encountered problems with juvenile offenses. Important to note that this bill does not automatically confer concurrent jurisdiction, but rather it makes it permissive. It opens the door to negotiations between the state and military installations. In addition to establishing a general process for retrocession, the proposed policy includes a statutorily supported memorandum of understanding between military installations and state officials. Under this paragraph, the state and installation would then together define the working relationship to support the activities associated with concurrent jurisdiction once it is established in law through this legislation. This bill is critical to preventing adverse impacts to the health, safety, and welfare of juveniles and the military community. As a representative of the United States Department of Defense, I am here before you today to ask for your assistance to ensure that concurrent jurisdiction may be established for federal military installations in Kansas. Overall, we are grateful for the tremendous effort that Kansas has historically given in supporting our service members and their families. And I stand by for any questions you may have. Thank you.
Thank you. Is there anyone else wishing to testify as proponent on the bill? Not seeing any. Want to direct your attention, committee, to proponent written only testimony from Lieutenant Colonel Keith Marshall, the Adjutant General's Department, and we will open it up for any questions. I do have a question. It's been talked a lot about juvenile cases, but this would be concurrent jurisdiction for any case. Is that correct?
If I may, Madam Chair?
Sure. Please go ahead and re-identify yourself.
Michelle Richard, United States Department of Defense, Defense State Liaison Office. This bill is general in the sense that retrocession of jurisdiction or jurisdiction that could be offered by the installation could be partial or full. It could be juvenile only. It could be, it gives the most flexibility for the state and the installations to negotiate and decide what is best for both parties.
Thank you. Is there a fiscal note associated with this? I don't see one in our folder, so I guess we'll need to request one to see how that would impact. And we're talking about civil and criminal matters, is that right, for the proponents?
Madam Chairman, this is Jonathan Sullivan from McConnell. With the concurrent jurisdiction or the retrocession, we're anticipating criminal, but it could also affect civil process. But what we as proponents, and I think what we're anticipating, we're looking at a strictly criminal sense with the MOUs or contemplated possible MOUs with local jurisdictions. But civilly, it could open civil process, although civil process is already an effect on the installation. Civil process is allowed to be served on military installations already.
Thank you. And to, I guess, answer my own question, the supplemental note indicates that a fiscal note was requested from the Office of the Attorney General, but the agency had not responded at the time of fiscal note publication. So would that be something committee would request would be followed up on? Other questions? Not seeing any, then thank you very much. Oh, we have one. Senator Rose.
I don't know who this is. Thank you, Madam Chair. I'm not sure who this is directed to, but should this be limited to military installations or just to any property, real property owned by the federal government?
Is that a question someone from the proponent side wants to take on?
Madam Chair, I'm happy to chime in or answer. We're, as the Department of Defense, our interest really is with military installations. We certainly would not object to expanding it, but that's not something that we're here to support either way, neutral.
Thank you. Other questions? Not seeing any, then we will ask, are there any neutral or opponent conferees wishing to testify on the bill? Not seeing any, and this doesn't impact tribal lands or has no impact on tribal lands. That's correct? This is just Department of Defense installations as stated in the bill. That's for the reviser?
Sure. Thank you, Madam Chair. And this kind of goes to Senator Rose's question a little bit. If you look starting at lines 20 and 21 on page 1, so it'd be United States to establish concurrent jurisdiction over land owned by the United States for military purposes. So it would have to be United States owned land, and that concurrent jurisdiction offer would have to be to the governor of Kansas. And so it doesn't speak to any tribal lands, since the jurisdiction of those would be under a different body.
And it wouldn't be owned by the federal government for other purposes either, per the bill anyway. Owned by the United States for military purposes. Okay, thank you. Any other questions? Not seeing any, then we will close the hearing on House Bill 2242. Thank you for your testimony. Appreciate you all appearing. Thank you. We're going to open the hearing on House Bill 2347, changing the culpability required for certain types of theft and increasing the criminal penalty for theft of property that is a motor vehicle to a felony. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2347 amends KSA 215801. This is the crime of theft. Under current law, one variation of theft with intent to permanently deprive the owner of the possession, use, or benefit of the owner's property or services, obtaining control over stolen property or services, knowing that property or services to have been stolen by another. This bill would change that provision to add a phrase after knowing, so it would be knowing or having reason to know the property or services were stolen from another. As originally introduced, the bill would have done the second part of what Madam Chair said at the little beginning there of the short title, which would be to add a new penalty for theft of property that's a motor vehicle with a value of less than $1,500, bumping that up to a felony. But that provision was removed by the House Committee on Judiciary. And I can take any questions.
Thank you. Any questions? Not seeing any. Thank you. We will hear from proponent Jan Jarman, Deputy City Attorney and Legal Advisor to Wichita Police. Please introduce yourself and welcome to committee.
Good morning, Madam Chair and Committee. I am Jan Jarman from the City of Wichita, and I stand before you in support of this bill. It's really a small change that we're asking for. The requested amendment to the statute applies to all theft, but really this is spurred by auto theft. We're looking for tools to help hold people accountable for possessing property that's obviously stolen. Auto theft increased in the Wichita from around 2,300 cases reported in 2023 to 2,650 cases reported in 2024. We have assembled task forces to deal with our property crimes. We're doing everything we can, and we're just looking for a little more help. Surveillance video and frankly flock detection has been helpful to us in combating some of these property crimes, but it's still very difficult to determine who originally steals the vehicle. The change we're requesting is in number 4 of the theft statute, which is possession of stolen property. And in these cases, it's not uncommon for a person who is caught driving a stolen car to not be the person who actually took the car. They hands off to other people very quickly. Often as soon as the car is stolen, it's taken to a motel or some other area, and another person takes possession of it and moves it along. So we can't prove who originally took the car. So we're proposing the change in number 4 of the theft statute from having to prove the defendant knew the property was stolen to also including that they may have had just a reason to know it was stolen. So instead of asking the fact finder to determine what the defendant knew in their head, it allows them to consider whether a reasonable person would know the property was stolen. I can think of evidence we might want to include would be like a punched column or no keys in the column, maybe broken window and with some glass laying on the seat. Maybe the driver doesn't know who owns the car. They have no plan of where to return it. When you ask them where they got it, it was from a guy named Bubba. They don't have a first or last name. Any of those factors could be given to a fact finder to determine that any reasonable person would have known this car was stolen. And so we're asking to change that and allow people to consider that. The second request is in that same section, in that it says currently that the prosecutor must prove that the property was stolen by another. And in auto theft cases, often the prosecutor can't prove who took it. And so only the person driving it had reason to know it was stolen. We can prove that much. They had reason to know it was stolen, but not necessarily who originally took the vehicle. And we think that that should be irrelevant in a case of possession of stolen property. It doesn't matter where it came from, only that the person who driving it knew it was stolen. So changing the wording to require the property was stolen from another person instead of by another person will help in proving that case. It'll help.
1 minute remaining.
Thank you. It'll help that they're guilty of possession of stolen property, whether they took it from the original spot or whether that stolen vehicle was passed on to them. Both of these small
We
changes,
appreciate hearing you. We can't see you. Something is now blocking your camera. There you go.
both of these small changes really don't fundamentally alter the original content of the statute. It only clarifies it and holds people accountable who are obviously possessing stolen property. And so based on that, we ask for your support, and I stand open for questions.
Thank you. Next, we will hear from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. Ed Klump with the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. I don't have much to add to what she said. She pretty much covered everything in my testimony. I do want to point out that the auto theft problem remains high. The 10-year average right now is still, our current rates are still more than 5% above the 10-year average for auto thefts. They've been dipping slightly over the past 2 years, but it's still a huge problem. These stolen cars, we find them being used in other crimes, robberies, burglaries, all kinds of things. This problem with the language that this is fixing is huge for us in dealing with this auto theft problem. Many, many times we catch people in these stolen cars, but we have difficulty in getting the prosecution because of the lack of this language. And I just want to point out there's 5 other criminal statutes that uses this language. And there's one traffic statute, which ironically deals with stolen antique vehicles that uses that knows or should have known language. So we would urge your support on this bill. Thank you.
Thank you. Next, we will hear from Nick Reinecker, private citizen. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee for allowing me to speak today. My name is Nick Reinecker from Inman, Kansas. I am a proponent to this bill, and I'd just like to say thank you to your staff who went above and beyond their duty for me to be here. I believe the greatest threat to our constitutional republic is from within. When the Constitution is diluted and laws are not made in pursuance thereof, or there is a failure to enforce and penalize those who violate constitutional laws, there's consequences. I hear the word evil in conversations under this dome. You know, like what they did to that child was evil, or driving a vehicle into the crowd was evil. Yet, so often this body doesn't follow through with applying the judicial justice after that observation. You know, we have our judicial seal out there that has one hand coming out, I think representing God, who has blessed us with a conscience. So how do we know that stealing is wrong? Because we have guilt and pain, and that's a good thing. It says, stop, this is a dangerous path, don't continue. And regardless of a naturally designed family to help correct certain behaviors, our current penalties and systems do not do justice and do not promote accountability, which actually helps to grow tactics of deception and manipulation and reinforcing the high of the adrenaline rush of risk-taking. Now, I'm not advocating for cutting people's hands off, but I'm also saying that maybe we should stop blaming unmeasurable chemical imbalances or childhood trauma for
Mr. Reinecker,
criminal
could you make
activity.
sure you keep your testimony on the subject of the bill?
So I
Thank you.
went to the library, and if I could put into, I just did this morning to my testimony, if you'll allow me to add it. It's the general statutes of the state of Kansas from 1868. On page 332, it says, Section 78, every person who shall be convicted of feloniously stealing, taking, and carrying away any money, goods, rights, value of $20 or more, or any horse, mare, gelding, etc., which in that day the vehicle could be considered like the horse was. These persons convicted of grand larceny, as it shall be called, shall be punished in the following cases as follows. First, for stealing a horse.
Could we make sure we're sticking to relevant testimony to the bill in front of us?
Absolutely. As far as increasing penalties, I would like the amended to increase penalties. Example would be hard labor and not exceeding confinement of 7 years. So what we have, I don't think we necessarily have enough penalties for this. And we all have a conscience and culpability, so that language should be in there as well. One final thing, if anybody wants to ask or inquire about how to affect the bed impact issues that may come up, I have some suggestions for that as well. Thank you, ma'am. I will stand for any questions.
Thank you. Is there anyone else wishing to testify as proponent on the bill? Not seeing any. Committee, we do have proponent written only testimony from Craig Sepich, Director, Office of Strategy, Policy, and Government Affairs, National Insurance Crime Bureau. With that, we'll open it up for any questions. Senator Haley.
Thank you, Madam Chair. To one of the last points, did we have bed impact from Kansas Sentencing Commission on this? I didn't see one. I don't know if anyone had. Was there one presented?
It's checking for bed impact statement.
We did have one on the previous, Madam Chair.
I don't think committee received one on that, so that would need some follow-up.
In hearing that, it does seem as if it could be significant. I don't know that there would be a change with it, so I do appreciate it. Thank you.
Other questions? I have a question for Mr. Klump and maybe for the reviser. You had mentioned that this is similar to 5 other criminal statutes, the language in lines 15 through 17 on page 1 of the bill. And it's knowing or having reason to know. Is it generally in our statutes it's knew or should have known? Is it usual to say having reason to know? And I know we're talking about gerunds because knowing instead of knew. So just wondering if we have having reason to know is term of art that we use in other statutes, either for Ed or the reviser.
Thank you, Madam Chair. So the concept is in a few of our other statutes. The reason that it doesn't say or should have known is if you read it with the lead-in, that phrasing doesn't quite work
with the knowing.
sentence. Yeah, because it's knowing instead of
using a gerund.
Knew or should have known. You know, normally it's knew or should have known, but because in this instance we say knowing, our culpability statute does define what knowing includes, and I can read that to you if you want, but this idea of should have known or having reason to know is in a few of our statutes. It's not in very many of our criminal statutes. We usually tend to stick to those 3 levels of culpability standards, but this wouldn't be the first instance of it.
Thank you. And a question then regarding the House amendment. I see the House struck making this crime a severity level 10 non-person felony and retained the position in current law that it would be a class A non-person misdemeanor. So was there any thought from the proponents on the change that the bill as introduced would make this crime a felony, and the House amended it back to maintaining it as a misdemeanor? Yes, Mr. Klump.
Well, we do still support that concept. We believe that theft of a motor vehicle, when you're in that class of vehicle that's valued less than $1,500, has long-ranging effects on the victims in those cases, in many cases. You look at who has vehicles in that price range, and it's the people without a lot of financial resources, and oftentimes they don't have insurance to cover the loss of that vehicle. They need that vehicle to get to work, get their kids to school, go to, doctor, whatever. And so, somebody like me, I have 2 vehicles. Somebody steals one of my cars, I'm at least not left riding a bicycle or walking. And that's not the case with some of these. The controversy came up in the House, to be honest with you, that what about, they go steal a junk vehicle sitting in my backyard that's valued less than $1,500, and that conversation is why the House took that out. I still think there's some remedies to that, but we weren't able to work those out on the House side. Like I say, a Class A misdemeanor for stealing a vehicle just doesn't seem right in a lot of those situations, and we see a lot of that in the areas of our communities where we have a high volume of people with low financial resources. And so that's why we were pursuing that. But
Appreciate that explanation. So, yes, Senator Haley.
Thank you, Madam Chair. I don't get too many opportunities to join the assessment of Chief Klump on this, but I absolutely concur and have for many years in this committee been concerned with the threshold for what theft is. We had for one time for other thefts at 1,000, and myself and a previous member of the committee who were on opposite sides of many issues, I'll invoke Mary Pilcher Cook, Senator Pilcher Cook, we agreed these crimes that disaffect the value at 1,500 at this, I don't know if that's an arbitrary amount that's put in place as to what the value of the vehicle would be, but they do, as Chief Klump said, disproportionately, and why this is being excluded or why this is being taken from the bill is the converse, I think, of the reason that we're bringing it here. I know the House probably well-reasoned why it should be, but I feel, and very strongly, that we should certainly keep the penalty in place for maybe the word that would be that Mr. Klump was thinking is just say an operable vehicle under 1,500. So that would carve out the junk car sitting in a backyard. But an operable vehicle, whether it's worth $500 or 1,000, is often a mainstay, and its deprivation by a thief of whoever owns it can have cataclysmic results. I didn't mean to go on and on, Madam Chair, but I do think, and plus I don't get an opportunity to work in conjunction with the good proponent of this measure, Mr. Klump.
Madam Chair, if I might, Ed Klump with the Law Enforcement Associations. We looked at that operable kind of convention in the House, and we were concerned then that if you're $10,000, or if your $1,400 car breaks down on the side of the road, is it operable? At that point, is it? And we didn't think that grabbed the scope of what we were going after. And as we looked at that, we also found when you look at the definition of motor vehicle in the statutes, it's wide-ranging. So the fix that I would recommend the committee to consider if you're going to go down this path, which we would appreciate, is rather than saying value under $1,500, a value over $500 but less than $1,500. And that will rule out all those oddball vehicles that would be covered. It would rule out the junk vehicles sitting in the back. We may miss a couple, but in our research of the data, we think that would catch the majority of those vehicles that are actually operational, registered, being used on the street if we'd break it down that way. So just an idea, thought, suggestion, not one we floated by the House in committee or anywhere.
Thank you for the suggestion. That was going to be my question. How much of the theft of motor vehicles occurring is in this value range of less than $1,500.
And I'm sorry I didn't bring that data with me. I had it in my testimony to the House. I think it's, I think it was like 12% of the stolen vehicles are under $1,500. So it's a significant number. That may not be totally accurate. Don't quote me on that number, but it's in that range somewhere.
Thank you. And Mr. Reinecker, I see you're waiting, but do you have a reply? It's really a question directed to law enforcement, but if you have a quick comment, and then we'll get to Senator Klemp's question.
Nick Reinecker, Inman, Kansas. I would just think about what the cities were talking about as far as a misdemeanor being something that they could do versus being a burden to the district court because we would be calling it a felony under that. So I put down number 4 on my references here, some information regarding that specific deal, and just to make sure that we don't put the burden of the victim under the burden of the district court.
Thank you. Senator Klemp.
Thank you, Madam Chair. My question is Mr. Klump. And you may or may not have the answer. The percent that you just referenced, was that the percent driven off of volume or the price point when you were capturing your?
Ed Klump, the Law Enforcement Association, it's the percentage of the number of thefts.
Thank you.
Where the value is listed in the offense report as being less than $1,500.
And that's around 12%-ish.
I think that's the right number. I can get back with you and make sure I've got that right. I had it in my House testimony. I just didn't bring that with me.
I was just curious more in the.
I'll make sure we get that information back to you.
Thank you. Thank you, Madam Chair.
Okay. Madam Chair, one thing I might say in addition, that $500 and $1,500, you might remember that the bottom line for felony theft several years back was $500, and it was raised, had been raised several years back to $1,500. But looking at the data also, like I said, for the value, because the KBI broke that out to me, and how much was less than $500, how much was $500 to $1,000, how much was $1,000 to $1,500. It looks like that break would give us pretty close to where we want to be on that.
Thank you. And do you know what percentage of the 12% are prosecuted?
I don't have that information, and that information probably is going to be easier to come by now with the new court system, but with some of those being prosecuted perhaps in municipal court, that makes it even more difficult to get that information.
Thank you. Other questions? Not seeing any, then is there anyone who wants to testify as neutral or opponent to the bill? Not seeing any, then we will close the hearing on House Bill 2347. Thank you for your testimony. We will next open the hearing on House Bill 2177, increasing the criminal penalties for certain violations of fleeing or attempting to elude a police officer when the person has prior convictions of the offense. And with that, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2177 amends KSA 81568. This is part of the Uniform Act regulating traffic. Under subsection B in current law there, it provides that any driver of a motor vehicle who knowingly fails or refuses to bring their vehicle to a stop or otherwise flees or attempts to elude while given a visual or audible signal to bring the vehicle to a stop, who also commits one of the offenses that are listed there, would be guilty as provided in subsection C2. Those additional offenses, you'll see them listed in my brief: failing to stop for a roadblock, drives around tire deflating devices, engages in reckless driving, is involved in an accident, commits 5 or more moving violations, or is operating a stolen vehicle. Current law there provides that any of those drivers attempting to elude capture of a felony shall be guilty as provided in subsection C2. So we're not changing any of the offenses of this crime, we're just changing the penalty provision. So violation of subsection B1 or B2 under current law is a severity level 9 person felony. This bill makes it a severity level 9 when the person has no priors, a severity level 7 when the person has 1 prior, and a severity level 5 when the person has 2 or more priors. Subsection B3 provides that a driver of a motor vehicle who knowingly fails or refuses to bring the vehicle to a stop or attempts to flee or elude, and knowingly drives the wrong way in an opposing lane of traffic on a divided highway, or knowingly departs their appropriate lane of traffic into oncoming traffic, is guilty as provided in subsection C3. And here again, we're not changing the elements of the offense, but we are changing the penalties. So current law, that's a severity level 7 person felony, and this bill would make it a 7 if you have no priors, a 6 when you have 1 prior, and a 4 when you have 2 or more priors. And I can take any questions.
Thank you. Committee questions? Not seeing any. Then we will hear from proponent conferee Ed Klump, legislative liaison, Kansas Sheriff's Association, Kansas Chiefs of Police Association, and Peace Officers Association. You can say it better than I can, Mr. Klump, but please introduce yourself and welcome to committee.
Thank you, Madam Chair. Been a while since I appeared before your committee, right? Ed Klump, Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. The reviser explained what the bill does and how it does it, so I'm not going to go through all that. I just want to explain why we're here with this bill and why we think this is important. These attempt to elude, these pursuit cases, is a conscious decision made by that driver to not pull over for law enforcement when we're trying to stop them. And there's a wide range of reasons that happens. One of the worst ones, I think, is what we were just talking about in the other bill, is stolen cars. That's one of the reasons in a large number of our pursuit cases. And the problem we see with this is we have repeat offenders. And the repeat offenders now, it's the same level of crime, whether it's the first, second, third, fourth, fifth, sixth, whatever. And we thought that this was this activity is so dangerous to the public, creates so much danger to everyone involved, that there should be an increase. If they don't get it on the first time that they've been charged with a felony, we think those penalties ought to be stepped up. And so that's why it's proposed in the way it is. And we would just urge your support on the bill, and I'll be glad to answer questions.
Thank you. Next, we'll hear from Eric Smith, BSc CJ, Law Enforcement Professionals. Please introduce yourself and welcome to committee. Okay, we had him listed as being available on WebEx, but not seeing that he's on WebEx at this time, so we'll consider his proponent testimony as written. And we also have proponent written testimony from Lieutenant Roy Wise, Kansas Highway Patrol. Is there anyone else wishing to testify as proponent on the bill? Not seeing any questions. Senator Haley.
Thank you, Madam Chair. Chief, Mr. Klump, I'm concerned. We've had this discussion so many times before. Have you seen in the practice or among your association that an awareness of an increased penalty in any way deters at all? Anyway, I mean, this is the stacking effect, which many don't know. I'm concerned about that we're increasing our bed space impact, but we're not actually doing anything to address crime. Can you testify, or do you know if there's any, by increasing the penalty, that those who flee and elude would be deterred, or are we just filling up additional beds with a legislation that's feel-good legislation? Not to be argumentative, but.
So the short answer is no. We do not have any data like that. None of our data would reveal that. And I have not seen any studies on that. It's, you know, it's difficult to measure what didn't happen, and that's actually what we're kind of looking at, is what didn't happen because of what we did here. But you know, I just don't have the capability to go into that data or have access to the data that would be necessary to do that.
All right, I appreciate that, and thank you, Madam Chair.
Thank you. Other questions? Senator Rose.
Thank you, Madam Chair. I have another data question for you. Is there any data that shows a correlation between a person who commits this crime and that person committing other crimes or violent crimes, or any data like that you could share with us?
You know, I've tried to find data to be more specific on what the reason was that people that we engage us in pursuits had for running from us. And we know there's a number that it's like I had a suspended driver's license or things like that. But our experience is that people that are running for those reasons usually give up quicker than those that are running from felony warrants or because they're in a stolen car or they have stolen property or things like that. And then there's kind of a class in the middle that are intoxicated either on drugs or alcohol. And so they have a judgment issue, I think, because of their state, which is also illegal to be driving in that state. And so there's a kind of a combination there. But I have not been able to find anything that would reveal those numbers to where we could actually do a study on, you know, what percentage of our pursuits are created from those felony factors, what are precipitated through impairment and then the, you know, the other minor things. Good question. I wish I had the answer for you. I'd love to have those numbers too.
Senator Clays.
Thank you, Madam Chair. I'm not sure who to direct this to, but I was looking at this Sentencing Commission memorandum and the impact of this, and there really, it doesn't appear they feel comfortable giving us one. It says impact on prison admission. This bill would, but the total can't be determined. Same thing with prison beds, can't be determined. Well, why wouldn't it be determined? Can't we look back a few years and see how many of these crimes were committed and be able to extrapolate from that and determine what that number might be? I don't know who to direct the question to, but
For the bed impact?
Yeah, it seems to me that we would have that data, wouldn't we? Like, we would have the criminal data of how many people, you know, committed that at the other, you know, sentencing 9 or whatever it was, and then if we moved them over, what would that look like and how much that would cost? I guess I'm confused why we wouldn't have that data available.
Let me see if the reviser can shed some light on that.
Thank you, Madam Chair. The Scott Schultz with the Sentencing Commission puts those together, so we can certainly reach out to him and ask. I suspect that the reason they wouldn't be able to figure that out is because right now the penalty is not bumped up based on prior convictions. So when someone's convicted, you don't know whether it's their first offense or their third offense. So by not collecting that data currently, it'd be hard to tell how many are repeat offenders.
I see. Okay. Thank you.
Thank you. Other questions? Not seeing any. Then do we have anyone wishing to testify neutral? Then we will invite opponent conferee Emily Brandt, BIDS Legislative Committee, Kansas State Board of Indigence Defense Services. Please introduce yourself and welcome to committee.
Good morning. Emily Brandt with the BIDS Legislative Committee. I think that Senator Haley's question and Ed Klump's testimony sort of sums up our testimony here. There is no data to show that increasing the penalties for flee and elude is going to deter flee and eludes. And so we would respectfully ask this committee not to work this bill. Additionally, we would point out that felony flee and eludes are governed by a recidivist statute. So even though your flee and eludes don't increase in severity levels every time you commit them, on your third and subsequent flee and eludes, you're always going to prison. So even though it's a severity level 9 and crimes in Kansas range from, on the grid, 1 to 10, so even though it's relatively low on the grid, if you're at your third or subsequent, you're going to prison. Your presumption is prison. And secondly, we would point out that this body has decided to sort of increase the punishment for flee and eludes by making flee and eludes person felonies. So every time you get another flee and elude, you have a person felony in your criminal history. And so instead of increasing the severity level of the offense, every time you commit another flee and elude, what we're doing is we are increasing your criminal history score. So you might be an I, the lowest severity level when you commit your first one, but you commit a second fleeing elude, suddenly you're a D. You commit a third one and you're a B. And so that is how this body has chosen to sort of increase the penalties for flee and elude, is through criminal history by making it a person felony. I don't think we have, again, any data to suggest that making felony flee and elude a recidivist crime is going to deter recidivism. I would also direct this committee's attention to the fact that, like, other severity level 4 and 5 felonies in the state of Kansas include involuntary manslaughter, robbery, sexual exploitation of a child, aggravated battery. This bill is going to punish people who, and I know sometimes that people are injured or there is harm committed during flee and eludes, but not always. And so this bill is going to punish people who commit no harm to others as severely as people who have committed a murder, caused great bodily harm, who sexually exploit children. I just don't think, without any of the data that doesn't appear to be available or exist from the proponents, that this bill is a good use of this body's time, given the fact that this body has chosen to make flee and eludes person felonies, and also you have created a special sentencing rules for person felonies. I also just want to point out, it's not in my written testimony, but I work for the Appellate Defender Office. We represent people convicted of felonies in the state of Kansas from all Kansas counties. And so I took a small sampling from my office of my colleagues in recent months who have handled felony flee and elude cases where there were no prior felony flee and eludes and additional crimes occurred. 3 of my colleagues have represented individuals charged with felony murder, with the underlying felony supporting that being flee and elude. No priors. An aggravated battery and a flee and elude. No priors. Aggravated battery with a deadly weapon and flee and elude. No priors for flee and elude. Aggravated assault on a law enforcement officer and flee and elude. No priors. DUI and flee and elude. No priors. Law enforcement and prosecutors have tools at their dispense to properly prosecute and criminalize people who commit dangerous offenses while fleeing and eluding. And this, to me, suggests that it doesn't matter how many times they've fled and eluded before. People fleeing once are committing these kinds of dangerous felonies. So we just don't see the reason in creating a recidivist crime when it's already a person felony. You have a recidivist special rule, and there's no data to suggest that recidivist flee and eluders are the ones committing the most harm in communities. So I'll stand for any questions.
Thank you. Is there anyone else wishing to testify as opponent on the bill? Not seeing any, we'll open it up for any questions. Not seeing any, then thank you very much for your testimony. I appreciate it. With that, we will close the hearing on House Bill 2177. We've had a full day of bill hearings. Appreciate everyone's attention today. We do have an opportunity for some other work in committee, but we will do that another day. So please get your amendments ready for possible final action on bills. And with that, we'll thank all the conferees, those appearing to watch in person and online, and to the committee and to staff for their work. So with that, the meeting is adjourned.